The envelope was still in my hand when my brother's wife started laughing. Not a quiet laugh. The kind that fills a room, that bounces off the walls of a lawyer's waiting area and makes the receptionist look up from her keyboard. She had her phone out before I even reached the elevator, already texting someone, her acrylic nails clicking against the screen in short celebratory bursts. My brother stood beside her with his arms crossed and a particular expression on his face. Not quite a smile. More like the face of someone who has been holding their breath for months and has finally been told they can exhale. I pressed the elevator button and watched the number above the door count down from 7. I had just signed over my share of my mother's house. I want you to sit with that for a second before I explain, because the moment looks one way from the outside and a completely different way from where I was standing. My mother was diagnosed with early-onset Parkinson's in the spring of the year I turned 29. She called me on a Wednesday afternoon, the kind of mild, unremarkable Wednesday that has no business changing anything, and she told me in her careful, measured way that the neurologist had confirmed it. She said she didn't want me to panic. She said she had a plan. What the plan turned out to mean, over the following 2 years, was me. I am a paralegal at a mid-size firm that handles estate law and civil litigation. I have spent the better part of 6 years reading documents that most people would rather not think about. Power of attorney filings, healthcare proxies, contested wills, trust amendments that arrive in my inbox the morning after someone's family dynamics quietly implode. I know what coercion looks like in paperwork. I know what manipulation looks like in language. I know the difference between a clause that protects someone and a clause that traps them, and I know that the difference is often invisible unless you are looking for it. I also know, from sitting across from enough clients in enough conference rooms, that knowing something intellectually and experiencing it personally are two entirely separate categories of understanding. My brother, he is 4 years older than me, has been married for 9 years to a woman I will call my sister-in-law because that is what she technically is. Lived 40 minutes from my mother's house. I lived 12. I will let you draw your own conclusions about who was there on the days that mattered. It was me who drove her to the movement disorder specialist. It was me who reorganized her kitchen so the things she needed most were at counter height. It was me who sat with her medication schedule and her insurance claim denials and her occupational therapy appointments, and built a system around her life so that the parts she could still control felt like they actually belonged to her. My brother came on holidays and the occasional Sunday. His wife came slightly less than that. When they visited, they brought flowers and talked about how hard this must be for everyone. They never once offered money. My mother's long-term care insurance covered roughly 60% of what her care actually cost. The rest came from her savings first and then, when her savings ran thin, from a line of credit I quietly opened against my own name because I could not bring myself to tell her the gap existed. I stopped expecting help eventually. What I did not expect, and this is the part I have spent considerable time trying to understand, was that my willingness to carry the weight would be interpreted as evidence that I didn't need anything in return. My mother died in November. She died on a Tuesday morning in her own bedroom in the house she had lived in for 31 years. I had been there through the night. My brother arrived 3 hours after I called him. His wife arrived with him, wearing a coat I had not seen before, carrying a casserole dish. The conversation about the house began 11 days later. My mother's estate was not complicated on paper. The house, which she had owned outright, and a modest investment account that had decreased somewhat over the years of her illness. She had a will. The will divided everything equally between my brother and me. There was nothing ambiguous about it. What my brother proposed, and he proposed it at the kitchen table in the house itself, while boxes of my mother's belongings were still stacked against the dining room wall, was that I sign a deed transfer relinquishing my half of the property to him directly. His reasoning arrived pre-packaged. The house needed work, he said. The roof had issues. There was something with the foundation in the northeast corner that an inspector had flagged. Selling it as a shared asset would mean delays, legal fees, negotiations. He made it sound exhausting. He and his wife, he explained, were prepared to take the house as is, absorb the repair costs, handle everything. All I had to do was sign a simple transfer document and he would pay me a flat sum. He named a number that was approximately 40% of the property's assessed market value, and we could put the whole thing behind us. His wife sat across from me with an expression she had clearly practiced, sympathetic but practical. The expression of someone delivering difficult news on behalf of the universe. I asked a few questions. Neutral questions, the kind you ask when you are listening rather than deciding. I asked about the roof assessment. Which contractor? What timeline? I asked about the foundation issue. What specifically had been flagged, whether there was a written report. My brother answered with the comfortable vagueness of someone who expects not to be pressed. I said I needed a few days to think about it. His wife's expression adjusted almost imperceptibly, a small tightening around the eyes that I catalogued and did not comment on. Over the next 8 days, I received 14 text messages and 6 phone calls. Some of them were from my brother, most of them were from his wife. The texts from her had a specific architecture. They began with warmth, pivoted to practical urgency, and closed with a sentence that implied, "My hesitation was a form of selfishness dressed as grief." One of them said, and I am not paraphrasing, "You're not the only one who lost her." I drove past the house on a Thursday evening after work. I had a key. I let myself in, walked through the room slowly, and then I called a friend of mine named Gail, who has been a licensed real estate appraiser for 11 years, and asked her to meet me there on Saturday morning. Gail walked through the house for 40 minutes. She looked at the roof from the backyard with a pair of binoculars she keeps in her car for exactly this reason. She pressed on the drywall in the northeast corner of the basement. She pulled up the county assessor's database on her phone and read me comparable sales from the previous 8 months. There was nothing wrong with the roof. The foundation corner had a hairline cosmetic crack that she said was so standard in houses of that age and construction that she would not have mentioned it in an assessment. The number my brother had offered me was not a reasonable discount. It was a number designed to sound like a reasonable discount if you didn't check. I sat in my mother's kitchen for a long time after Gail left. Then I went home and called a contractor I know through work, someone who does assessments for estate settlements, and asked him to go through the house formally the following week. I called the county assessor's office and requested the current official valuation. I called a title company and asked about the process for a voluntary deed transfer and what documentation would be required, and what, if anything, might make such a transfer reviewable after the fact. The woman at the title company mentioned in passing that our state had specific provisions around transfers made under what she called undue influence, particularly in situations involving recently deceased estates, where one party might be in a compromised emotional position. She was not giving me legal advice, she was just explaining how these things worked. I found that information very useful. I called my brother the following Tuesday and told him I had decided. I said I understood the situation, that I didn't want the house to become a source of ongoing conflict between us, that I was willing to sign the transfer. He was warm in a way I had not heard from him in weeks, a specific warmth that belongs to people who have gotten what they wanted and are relieved enough to briefly become generous. He said we could handle it through his attorney, keep it simple, no need to drag things out. I said that sounded fine. What I did before I went to that meeting, I had my contractor's written assessment in my bag. I had the county's official valuation, printed and dated. I had a brief, carefully worded letter from Gail on her professional letterhead noting that in her appraisal judgment the property carried no significant deferred maintenance issues, and I had, in the interior pocket of that bag, the same small digital recorder I had purchased 3 days earlier at an electronics store 2 towns over, tested in my car twice before I drove to the appointment. I want to be honest about something. I did not know exactly what I was going to do with any of it yet. I knew I was not going to walk into that room without documentation. I knew I was not going to sign anything in a state of unarmed trust. Whether what I had would matter, that depended on what happened in the room. What happened in the room answered that question for me. My brother's attorney had the transfer document ready on the conference table when I arrived. My brother was already seated. His wife was there too, which I had not anticipated and which told me something. She had dressed for the occasion in a way that was subtle enough to deny but real enough to notice. The attorney walked me through the document in the practiced tone of someone who has explained things to grieving people before and has learned to make the explanation sound like a kindness. I listened. I asked one clarifying question. The same question I had asked my brother at the kitchen table. What specifically was the nature of the foundation issue, and was there a written inspection report I could review? The attorney glanced at my brother. A short glance. The kind that carries a conversation. My brother said the report was with the contractor, that he could get it to me, that these were details we could sort out after, and here his wife placed her hand on the table, not quite interrupting but filling the pause after we got the main thing handled. She said she knew this was emotional for everyone. She said my mother would have wanted us to move forward. I looked at her for a moment, then I looked at my brother. I picked up the pen. I said, before I signed, I just want to make sure we're all on the same page about the property value. I named the county assessor's figure. I named the comparable sales Gail had pulled. I said the number my brother had offered me was significantly below both. The room changed temperature. My brother said the assessor's figures were theoretical, that real-world market conditions were different, that I was not accounting for the repair costs he was taking on. His wife said, and she said this with a clarity and volume that the recorder in my bag had no trouble at all capturing, that if I was going to be difficult about this, they would simply force a sale through the courts, tie it up in probate, and by the time it was resolved the legal fees would eat up whatever I thought I was protecting. She said that, clearly, in front of a witness who was technically her own husband's attorney. My brother told her to stop. But she had already said it. I signed the document. I thanked the attorney for his time. I stood up, gathered my bag, and walked out of the conference room into the hallway. I had 4 minutes before the elevator arrived. I used them to photograph the signed document with my phone. I had brought a copy for myself, which the attorney had looked slightly surprised by, and to send a message to a colleague at my firm who handles exactly this kind of case, attaching the audio file and asking if she had 20 minutes to talk that afternoon. She called me before I reached my car. What I need you to understand about the deed transfer I had just signed is that it was not, under the law of our state, automatically binding. A voluntary property transfer made within a short window following a death, where one party can demonstrate they were operating under emotional distress combined with documented misrepresentation of property value, combined with explicit verbal coercion captured in a recording, that is not a clean transfer. That is a transfer with problems. My colleague spent 40 minutes on the phone with me walking through exactly what we had. She was not generous with her optimism. She was careful and specific, the way good attorneys are when they do not want to set expectations they cannot meet. But she said the recording was significant. She said the discrepancy between the offered price and the assessed value, documented by an independent appraiser and the county's own records, was significant. She said the timing, 11 days after my mother's death, before probate had even been formally opened, was significant. She said, file a challenge, let's see what they do. I filed the challenge on a Thursday morning. I submitted the appraiser's letter, the contractor's assessment, the county valuation, and a transcript of the relevant portion of the audio recording, the part where my sister-in-law explained that she would tie the estate up in court until the legal fees consumed whatever I was trying to protect. My brother called me that evening. It was the first time he had called me himself, not through his wife, since before our mother died. He sounded different, smaller, somehow. He asked me what I was doing. I said I was making sure the situation was handled correctly. He said this was going to destroy the family. I asked him which part of the family he was referring to specifically. I did not say it cruelly. I said it the way you ask a real question when you genuinely want to understand what someone means. He didn't answer. He hung up. The challenge process took 4 months. I will not walk you through all of it because most of it was paperwork and waiting, which is most of what legal processes actually are. My sister-in-law hired a separate attorney. My brother's original attorney withdrew from the matter, which I understand is a fairly legible signal about how he assessed the situation once he had reviewed the recording. The court found that the transfer had been executed under conditions that met the state's threshold for undue influence. The signed document was voided. The estate returned to probate under the original will. My brother and I sold the house 6 months later, through a licensed agent, at a price that was 14% above what my brother's original offer had implied the house was worth. After fees and taxes, my share was enough to pay off the credit line I had opened during my mother's illness, with a small amount left over that I put toward a new furnace in the apartment where I actually live. I did not feel triumphant. I want to say that clearly because the story has the shape of something triumphant and I am not sure that is the honest version. What I felt mostly was a deep and specific tiredness. The kind that lives below the surface of normal tiredness, in a layer that sleep does not really reach. I have not spoken to my sister-in-law since the court's ruling. My brother and I exchanged the necessary communications during the sale process through our respective attorneys, and then, once it was complete, through occasional short texts that are polite in the way that texts between people who are no longer sure what they are to each other tend to be polite. We have not had a real conversation. I don't know if we will. I spent a long time trying to locate the exact moment when what I provided was reclassified in their minds from something I was choosing to do into something they were entitled to expect. The caregiving, the financial covering, the presence. I don't know when it happened. I know that it did happen, and I know that I almost missed the moment when the same logic was being applied to the house, when my grief and my exhaustion were being treated as a resource to be managed, rather than a state that made me vulnerable to being taken from. The recorder cost me $32. I still have it. I keep it in the same bag, in the same interior pocket. I don't know exactly why. Maybe because there's something clarifying about knowing it's there. Maybe because the version of this story where I didn't have it, where I signed the transfer and went home and found out later that everything in that folder was a performance, that version is still somewhere nearby. Not haunting me, exactly. More like a thing I pass on the street and nod to. A reminder of how close the margins can be. I'll ask you something, and I mean it sincerely, not as a way of wrapping things up neatly. If someone you loved and trusted handed you a document during the worst month of your life and told you that signing it was the only practical option, how carefully would you read it? And what would you be willing to do if, when you finally did read it carefully, you realized that the person handing you the pen already knew exactly what you'd find? I've thought a lot about the word practical since all of this ended. My sister-in-law used it constantly. It's the practical thing to do. We're just being practical. Practical was the word she wrapped around every instruction, every deadline, every quiet threat. And for a while, I almost let it work. Because when you're exhausted and grieving and someone speaks to you in the language of reason, part of you wants to believe that following along is the same thing as being wise. It isn't. What I've come to understand is that clarity and exhaustion cannot occupy the same space at the same time. That's not a weakness, it's just how people work. My brother and his wife understood that. They timed everything deliberately. The kitchen table conversation 11 days after my mother died, the escalating texts, the appointment with the attorney already scheduled before I'd even said yes. They weren't being practical, they were being strategic. And they were counting on me being too tired to tell the difference. The thing that saved me wasn't luck. It was a habit I had built over years of professional work. The habit of checking, of not accepting a number because someone said it with confidence, of asking for documentation that should exist if the story is true. Gail walked through that house in 40 minutes and found nothing wrong. The county assessor's office had a valuation on file. The contractor put his assessment in writing. None of that required brilliance, it just required the willingness to look before I signed. I think about that sometimes. How much of what gets taken from people is taken not by force but by the careful management of their attention. You're told to focus on the grief, the logistics, the family piece, the practical thing. And while your attention is there, something else is being moved. My brother is not a villain in the way that word usually gets used. He is someone who wanted something and found a way to justify taking it that felt, probably, like good reasoning from where he was standing. His wife is someone who is very good at making that reasoning feel airtight until it isn't. The version of this story where I didn't call Gail, where I signed and went home and found out later that version existed. It was close. I pass it sometimes and feel the weight of how close it actually was. What I keep returning to is this. Integrity isn't just about what you do when people are watching. It's about what you do when you're the only one who would ever know. I could have let the exhaustion win. No one would have blamed me. Grief is a reasonable excuse for almost anything, but I would have known eventually that I handed something over that wasn't mine to hand over. That I had let someone else's confidence substitute for my own judgment at exactly the moment my judgment mattered most. There's a version of resilience that looks like toughness. This wasn't that. This was quieter. It was buying a $32 recorder and testing it in a parking lot. It was making one phone call to a friend who knew more than I did about houses. It was sitting still long enough in my mother's kitchen to decide that being tired was not the same thing as being finished. The house sold. The credit line is paid. I still have the recorder. Some lessons cost more than others. This one cost me 4 months and a relationship I'm not sure how to name anymore. But it gave me something too. The knowledge that I checked, that when it mattered, I looked carefully at what was being handed to me and I asked the right questions. That's the part I want to hold on to.